It's interesting at this stage of the debate to just recollect a little bit about where we've travelled and the number of people who have spoken and a number of the points that they have made in this little piece of this committee stage, which allows us to take a view over the whole bill. And I wanted to make 2 or 3 points. The first point that I wanted to make was that in the course of the preparation of the minority report, the Labor members prepared a 3-page, fairly extensive piece of minority report. Missing from any of that was any talk about DNA. And it's been quite interesting to see the debate that they've had in respect of the conflict they seem to find between natural justice and the Bill of Rights and taking of DNA samples. We heard a speech earlier where apparently 12 and 13-year-old children were going to be held down and have a DNA sample taken from them. Now, of course, the DNA sample is taken by the young person themselves by taking what we would know as a Q-tip and rubbing it on the inside of their cheek and putting that into a plastic bag. It is not taken from them in the way of a burly policeman holding the 12 and 13-year-old down. And it's important for those people listening and making an assessment on the validity of the speeches in the House to know that fact. Another point was made about the 12 and 13-year-olds being children. And of course, by definition, under this Act, and the Crimes Act, a child is defined as somebody under the age of 14. And so by this criminal definition, under the Crimes Act, 12 and 13-year-olds are children. And on their 14th birthday, they become young persons. And then on their 17th birthday, they become adults. Now, from the other side of the House, we don't hear any disagreement with any of that in relation to when they become children. The age until they become young people. We do, of course, because they disagree with it, have a problem with people becoming adults when they're 18. But that is the Act that we're dealing with in relation to the Crimes Act and in relation to the Children and Young Persons and Their Families Act. It's important too to restate the point the Minister made in respect of the offences for which DNA will be taken off 12 and 13-year-olds. And these are crimes that are punishable by more than or by 14 years imprisonment or more. So we're talking, for instance, with wounding with intent to cause grievous bodily harm. And the member, the Honourable Leanne Dalzell, has spoken on numerous occasions about a tragic murder that involved half a dozen young people, the youngest being aged 12. Now, if we think about that situation, if the victim in that attack, Michael Choi, did not die, then the 12-year-old offender who rang the pizza place to have the pizza delivered and who opened the door for the victim to be allowed into the house, but apparently did not wield any implement that actually brought about the murder, he could not have been charged and would have not been charged with anything. He may have appeared as part of a care and protection process through the family court and been dealt with that way, but is not charged. And then also under this legislation, a DNA sample could not be taken in any event whatsoever. And so the point that the Minister made quite ably too was this. Knowing the offending that went on by some of our most notorious offenders like Joseph Thompson and Malcolm Rewa and Graham Burton, if you had the opportunity to secure a cheek swab that held the DNA of any of those three offenders, with them having committed a crime punishable by 14 years or more imprisonment, why wouldn't you take it? Why wouldn't you take the opportunity to prevent, for instance, in respect of those two of those offenders, that they went on to have at least 100 more victims in respect of rapes of people in their own home? Knowing that if we had, for instance, their DNA on record, their DNA profile on record, then as soon as they left a bodily secretion of any kind, they could have been identified and may well have prevented the other of those 100 or so victims. I believe very strongly that aligning this piece of legislation with the DNA sampling legislation is a very real step which will prevent a huge, Mr Chair.
Chester Borrows.
Mr Chair, which will prevent, it will be the legislation that prevents more victims than any other piece of legislation this House is ever likely to pass. That's the DNA sampling bill. Aligning the ability of this Act to present 12 and 13-year-old offenders having committed crimes of that magnitude is not something that even Harry Holland would have disagreed with, bearing in mind the way we actually treated 10, 12, 13 and 14-year-old offenders in Harry Holland's day. And I think it's important to try and take some of the emotion out of this debate and just look at it in real terms. Now, another point that was made has been made time and time again is the initial debate we had from fairly high-profile people within the sector who were anti the legislation, especially in respect of 12 and 13-year-olds. And we've heard Judge Andrew Beecroft quoted on many, many occasions, and the reason for it, of course, is because he's got huge credibility within the sector. It's interesting to note, though, that when he appeared before the Select Committee, and he appeared before the Select Committee about 3 times, I think, when he appeared before the Select Committee initially, his concern was that 12 and 13-year-olds who offend on this level and so would appear before the Youth Court under this legislation are actually few. But what we know is that their offending is very sophisticated and it is very violent, and we are now seeing a trend that involves young women as well as young men, which is a new trend. And his argument was, look, if you really want to help this, you want to streamline the process of being able to move young people through the court system that involves 12 and 13-year-olds. And so what we responded to that, and he, when he came back, he actually was complimentary on the changes that were made, that what we've done within this legislation is allow, for instance, the process to move quickly. So a 12 and 13-year-old prolific offender that the police bring before the court system can appear before the youth court quickly, so they can have curfews, they can have prohibitions on associations with people and bannings from areas of high-level offending, and get them onto what in effect in an adult court would be called bail conditions, in a youth court would be called adjournment conditions, even if they go back and appear before the family court. So Judge Andrew Beecroft made the comment when he came back before the committee, when the changes had been made, that actually he didn't have a heck of a lot of a problem with this, because his suggestion was streamlining it, and that is exactly where it went. And when he returned again to the committee, at that stage some more flesh had been put on the bones of the military-style activity camps, and the government had started a pilot course. They didn't need legislation. That's right. They could do it with the consent of the child. Just remember that. They could only do it with the consent of the young person who was appearing, and we're changing that, and Labor agrees with that change. So let's not kick that around too much. But when the judge came back and he found out what was being offered in terms of programs while people were attending these military-style activity camps, he did not refer to them as boot camps. He did not align them with the boot camps being the corrective training that was going on at that time. Those members who were present, and actually there's not a heck of a lot of them on the other side who did hear him, but I'm sure Ms Ardern will recall that when he came back and when it was explained the programs that went along with military-style activity camps as they were being run at that time, he did not refer to them as boot camps. In fact, and directly in response to a question from me, he said that they were completely different from boot camps that had been commented on within the media and within those commentators being reported in the media. What he said was that he agreed with the programs that were being offered to people in the military-style activity camps, and he agreed that the sort of style of camp that we were running in supervision with activity that are now part of military-style activity camps actually were having the best results. That is what he said. So I'm pleased to stand here today because this is a piece of legislation that a number of us have worked on for a long time. In opposition, the Honourable Anne Tolley and myself spent a lot of time looking in the youth justice area, visiting a number of providers around the country, and the youth justice discussion paper that was the forerunner of this, along with those other members of the Law and Order Caucus Committee in opposition, very proud of this